An appeals court says the charges stand and the Crumbleys are headed to trial. A major decision in the case that could set a precedent across the country. Thanks for being with us, everyone. I'm Kimberly Gill.
And I'm Karen Drew, in for Devin Skillion tonight. The Michigan Court of Appeals released its decision in the case today. The pair is charged with involuntary manslaughter in connection to their son's deadly shooting at Oxford High School. The panel says there is enough evidence that the tragedy was foreseeable. Sean Lay live on the story for us tonight. And Sean, take us through this decision.
The decision, 17 pages long. We've been going through it line by line, and it really boils down to this from the Court of Appeals. They are pointing to the meeting at the school the day of the shooting. Parents, student, and school administrators. The judges are saying, Karen and Kimberly, that the parents never mentioned at that meeting their son's mental health status, never mentioned that they bought a gun for him, never checked the backpack. They say to the parents it was foreseeable what could happen next. In this bombshell ruling, the Michigan Court of Appeals ruling that, yes, there is enough evidence to send the parents of the Oxford High School shooter to trial on charges of involuntary manslaughter. The three-judge panel listed off the staggering number of red flags waved at Jennifer and James Crumbley by their own son in the months, days, and hours leading up to the school shooting. That the judges say the parents could have prevented the shooting by getting their son the help he was begging for, but they ignored him. The judges cite text messages the son sent to Jennifer Crumbley saying that there was a demon in their home and he was scared. The judges point out there was no response to him. The son sent a text back to his mother. Can you at least text back? The judges point out that the parents bought their son a handgun and failed to secure it at home. A gun lock was still in its original package at home. Prior to the ruling, this hearing at the Court of Appeals where judges asked the Crumbleys' attorneys and prosecutors key questions about the case.
What do you fault the parents for most? Not opening the backpack, not taking him home from school, something else?
Judge Christopher Murray writing in today's ruling that the Crumbleys' son, quote, would not have been able to shoot and kill 4 students but for defendant's decision to purchase their mentally disturbed son a handgun, their failure to properly secure the gun, and most importantly, their refusal to remove him from school when he made overt threats to hurt other people. Back here live, there's more here. Just got off the phone with a local defense attorney not connected to the case saying, look, what's the impact, the ripple effects here? Should parents be looking at this if their child commits a crime? And he was saying this is such a unique case, it's really unclear what's going to happen going forward here, and he expects the case here now to go to the Supreme Court after the Court of Appeals has ruled. Karen, Kimberly, back to you.
Definitely a landmark case. I know the whole country is watching how this is going to be handled. So that being said, following the rulings today, will things move quick or is this going to be a slow roll?
Yeah, quick right now because we just checked with Oakland County Courts. A status hearing has already been set up for May 25th, so that's not too long from now for the parents. That's when prosecutors and the defense attorneys and judge may try to set up a trial date. But again, Supreme Court ruling or asking the Supreme Court about this is likely next.
All right. Sean Lay reporting live for us tonight. We appreciate it. Thanks, Sean.